I had the most pleasant ITAR-related conversation with my buddy Steven. And I know what you're thinking. How the heck darn could an ITAR-related conversation be pleasant? Well, that's for me to know and for you to find out in this episode of the Trade Compliance Talks with me and Steven Casazza. Enjoy. So, hi, Stephen, and welcome to the Trade Compliance Podcast and this episode of the Trade Compliance Talks. And could you please introduce yourself?
Absolutely. Thanks, Anders. I'm Steve Casazza. I'm president of Defense Trade Solutions. Defense Trade Solutions, we provide managed and advisory services in the trade compliance arena, foreign military sales arena, and technology security and foreign disclosure arena to aerospace and defense companies, really on how to navigate export control and compliance requirements, and ultimately enable a safer world through international trade.
All right. Sounds awesome. And to address my favorite question, how did you end up in trade compliance?
That is an excellent question. So I stumbled into it, but I stumbled into it very, very early in my career. And really what happened was I was looking for an internship in college. And when I was talking to one of my fraternity brothers about different internship options, I was majoring in international affairs and I didn't know what, internship I was going to do. And there weren't, I applied to a couple things, didn't get the internship. And he mentioned to me how his father was a senior vice president at General Dynamics, and they have a pretty good internship program. And so I applied and they put me on a contract with the Deputy Assistant Secretary of the Army for Defense Exports and Cooperation. And what was interesting is they had a project that nobody else wanted, and they thought it would be great to give it to the young college student to go, because this project wasn't going to go anywhere. It wasn't going to do anything. It was something that came from their superiors in DoD. And that project was ultimately export control reform and the rewriting of the U.S. munitions list. So one of the things I was responsible for and doing as a college student as part of my internship was really going and providing the U.S. Army's perspective on rewriting the U.S. munitions list as part of export control reform, which was pretty exciting. And so after that, I stayed at dissect to review export licenses on behalf of Department of Defense and review FMS cases on behalf of Department of Defense for export policy reasons. Left dissect to go work as an empowered official at Sierra Nevada Corporation. Was there for a number of years. Left Sierra Nevada Corporation to go work at General Atomics, doing technology release for them out of their DC office. And at around that time, I decided to start Defense Trade Solutions and provide that comprehensive export control approach and really guidance on the Arms Export Control Act to small and medium-sized companies. That sounds really awesome. And it sounds like you were thrown into the action right away. Yep. And whenever I tend to ask that question too. And whenever I ask somebody that, it seems like the general trend of export compliance professionals is that we either stumble into it or are thrown into the action right away. And there's a lot of just figuring things out as you go. There's no real, textbook or training or college course or anything like that really prepares you for these types of challenges.
No, really. It's the same story for me. Basically, I was pursuing a career as a supply chain development or a organizational development or HR, something like that, as a freelancing consultant. And I had a plan, a really good plan, I thought, and it all went sideways and I ended up with trade compliance. So, but I haven't regretted a day because it's complex and it's a never ending story. So any day isn't anything like the day before, and you really get to meet fantastic people and really get challenged in your everyday work. Moving on to the topics of today. First off, we're going to talk a little bit about the Arms Export Control Act, or AECA. Every time I say that acronym, I want to say YMCA, but that's a whole nother story. But could you please tell everyone what the Export Control Act, the AECA, really are and what the key objectives is?
Yeah, certainly. So the Arms Export Control Act, or the AECA, is really the legal authority given by Congress to the president and the executive branch of the United States, as well as U.S. defense industry, in being able to export defense articles, associated services, and data. And so in the United States, nothing happens without some kind of legal authority coming from Congress. And this is the overall legal authority for both the U.S. government as well as U.S. industry to engage in the export of defense articles, services, and data. And really, when we look at the AECA, the implementing regulations of the AECA is what most people are familiar with when they talk about export controls and defense, and that's the International Traffic in Arms Regulations, the ITAR. And so the AECA is that legal authority, that overarching authority that allows us to do what we do, and the ITAR are the rules and requirements that U.S. defense industry and, in a lot of instances, the U.S. government have to comply with in order to engage in that export activity.
So basically making trade at all possible. And how does the AECA integrate with other U.S. laws and regulations regarding arms transfers?
That's a great question. And so the AECA is what's called a Title 22 authority. And Title 22 is really the combination of legal authorities that are given to the U.S. State Department. And so the AECA is a State Department legal authority. So State Department has the oversight of the implementation of it. And really, State Department provides oversight to U.S. defense industry when they're engaging in arms exports through the International Traffic in Arms Regulations, but then also oversight to U.S. Department of Defense and other agencies when they're engaging in the export of defense articles and services. And, that could be the U.S. Foreign Military Sales Program of providing goods and services to allied partners. It's also any sort of overseas operation where the U.S. government is exporting defense articles to itself overseas in foreign locations. So it really is comprehensive and really provides that framework beyond just shipping boxes and selling goods to foreign allies. It's how really the U.S. operates all around the globe.
Yeah. Could you say that the ITAR and the EAR is like a product of the AECA?
So the ITAR definitely is. And so when it comes to the EAR, the Export Administration Regulations, that's nestled in under its own legal authority, which is the Export Control Reform Act. Because it used to be nestled in under the legal authority of the Export Administration Act, which are kind of like the AECA, but they're legal authorities given by Congress to the Department of Commerce for the legal authority to engage in commercial and dual use trade. So there's that. So when you're looking at trade from the United States, it's really two sides to the same coin. You have the Arms Export Control Act and the ITAR on one side, and then you have the Export Control Reform Act and the EAR on the other side.
Yes, got it. A fun note, in, for example, Europe, we have three sides. We have the military classifications, the military products and components, and the dual use, like you do. But we have also this third box that we called civil or uncontrolled.
Interesting. And it seems like on the U.S. side, we do the same thing. It's just in that dual framework as opposed to trilateral, where, when from a practitioner's perspective, we generally look at things in three buckets too, where you have the ITAR controlled categories on the U.S. munitions list. Then you have the EAR, which we kind of view as two separate lists. You have your dual use, and that would encompass your what we call 600 series items, where they're military, but they're also dual use applications, and they don't warrant the control that the ITAR, provides. They require a step down level of control. And then you have your commercial and very minimal level of control items, largely what we call EAR 99, which is basically, no license required to any country except those with a trade embargo. So in practice, the three levels make sense, but on the US side, we have two lists.
Yeah, got it. What do you think is the biggest challenges in understanding and complying with the AECA?
So there are a couple. The first is understanding that the AECA and the ITAR apply to both tangible and intangible exports equally. So when you're a US defense company, whether you are exporting a defense article, let's say an F-16, or you are exporting information about the F-16 that is technical, or you are providing a service to a foreign country's F-16 that they've bought previously, all of those things require some kind of export authorization to take place. And it is very, very hard for new exporters to have the paradigm shift of understanding that the requirements in the ITAR apply to the intangible export activity just as much as the tangible activity. I know when I was just getting started in this, one of the first questions that I got asked as an intern was, what is an export? And I wrongly was like, it's when you ship something outside the United States. And that is the paradigm that most people enter this space with. And it couldn't be farther from the truth. In fact, I would say most of our customers, when we're building out ITAR compliance programs for them and we're getting ITAR export authorizations for them to go and operate, most of the time it's for the intangible export activity. It's for the services, it's for the marketing technical information, it's for providing training to foreign equipment or to equipment that was already exported to a foreign customer. So that intangible piece is very, very important and often missed. The second hardest challenge would definitely be jurisdiction and classification, understanding where your commodity falls, whether it is ITAR or EAR, particularly when you start to look at parts and components, because it is often assumed that if you're a part or you're a component, you're automatically EAR because you're not a big scary weapon system like the F-16 or something like that. But just because you're a part or component doesn't mean you're not controlled. In addition to that, when it comes down to software is very, very hard to figure out where you fall within the ITAR and the EAR. And knowing where your parts and components and your software's jurisdiction is the first step in understanding what rules apply to you. And so oftentimes companies and our customers are so focused on their sale that they forget about understanding the first step, which is first and foremost knowing the jurisdiction of the activity you're engaging in. So I think those two things are probably the most difficult challenges when navigating the ITAR and the AECA.
Yeah, of course. And then you have the situation where something could be subject to dual jurisdiction. For example, if you have a 600 series hardware and the defense service is controlled by the ITAR.
Right, absolutely. And we actually have had a number of customers where you're looking at the UAV market and they are either dealing with or developing an EAR controlled UAV. So a UAV that is dual use, nothing inherently military about it, but they are looking to take those UAVs and apply them to a military application. And what happens is they're looking to make certain small modifications to the UAV or install new software onto the UAV for how the UAV operates. That is very specific to their military customers. And working with them in that and getting them to understand that those modifications, though the foundational software or the foundational UAV might be EAR controlled, those tweaks are actually making it an ITAR controlled commodity and having to then deal with a completely different export licensing regime for those commodities. When you're dealing with customers, and particularly the sales side of their company, once something's developed, they want to be able to sell it to customers that they've had. And so kind of getting them to understand that, they'll need a license where previously they didn't. It's a difficult challenge sometimes.
Yeah. And you mentioned FMS earlier, and I believe that's a great segue into our second topic. That's major modalities of arms sales, foreign military sales, or FMS, versus direct commercial sales, or DCS. Could you explain the key differences between those two?
Absolutely. So we'll start with direct commercial sales, and this is probably the most commonly understood modality of sale for global trade practitioners. So a direct commercial sale is where you have a contract between a U.S. exporter or U.S. aerospace and defense company and the foreign government customer or foreign aerospace and defense company. And the mechanism that allows for the sale to take place is a export license between the U.S. defense company and the foreign government. So the U.S. defense company would go to the U.S. government and say, hey, we have either this proposed contract with this foreign government, or we have this contract with this foreign government. Here is the scope of the goods, services, and information we want to provide to this foreign government customer. Do we have export approval to go and do that? And once the U.S. government provides approval on the export license, then the company and the foreign government can engage and execute their contract. Okay. So a direct commercial sale is direct between a U.S. aerospace and defense company and the foreign government. On the other side, the second modality of sale is foreign military sales. And this is a little bit more complex, but it's becoming significantly more prevalent, particularly as we see what's happening with Ukraine, Israel, and more, I would say, robust sales occurring around the globe. So foreign military sales is where you have really a relationship between the U.S. government and a foreign government. And the foreign government asks the U.S. government for goods, services, information to really build up their military, build up their capacity. And what the U.S. government does is they then go and issue a contract to U.S. aerospace and defense companies to furnish those goods and services to the foreign government. So really, the U.S. government is in the middle. Mm-hmm. And what's interesting about foreign military sales is that there's really kind of two agreements at play. There's the agreement between the U.S. government and the foreign government. That is the foreign military sales case. And then you have the contract between the U.S. government and the U.S. aerospace and defense company. That is really where the U.S. government is buying those goods and services from the U.S. aerospace and defense company, or the U.S. aerospace and defense company to provide those goods and services to the foreign government, even if the foreign government is the one that's actually paying the U.S. government to get those goods and services. So the U.S. government is really I wouldn't say intermediary, because they have a very, very significant role in this happening, but it's the middle point between the transfer from the U.S. company with the foreign government.
So could you say that the deal is facilitated like government to government, but the U.S. industry is the supplier?
Correct.
Yeah. And what are the main actors involved in FMS and DCS respectively?
Yeah. So when you're looking at direct commercial sales, the main U.S. government actors are the main U.S. government offices involved in really any export licensing request. So the U.S. company will submit the export license request to the Directorate of Defense Trade Controls and U.S. State Department. The Directorate of Defense Trade Controls, or DDTC, then staffs out that export license request to different offices within State Department. So you have the regional bureaus from a regional foreign policy perspective. They'll staff it to the Office of Regional Security and Arms Transfers. And so that is the main national security and foreign policy review for arms transfers within Department of State. They are very, very important, and they're probably the real owners of the Arms Export Control Act from a foreign policy perspective. DDTC will also staff to offices like the Office of Democracy, Human Rights, and Labor from a human rights perspective, as well as some others from a non-proliferation perspective that tend to happen depending on the commodity at play. DDTC will then also staff export licenses to Department of Defense. And the main office within Department of Defense that receives the export licenses is the Defense Technology Security Administration, also known as DITSA. They're within the Office of the Secretary of Defense for Policy. And we'll get back to that in a second, but they're nestled within OSD policy within Department of Defense. And then what DITSA does is staffs out the export authorization again to all of the different military services. So Army, Navy, Air Force, sometimes NSA from an intel community perspective. And all of those offices within Department of Defense consolidate a position back to DITSA. DITSA then takes that position and provides a national security recommendation to DDTC. DDTC takes that national security recommendation and takes the foreign policy recommendation from the other State Department offices, and you get your export license approval. And that's why sometimes exporters will see 100 different provisos and restrictions on their export license, because you have sometimes 43 different offices all providing their perspective on the export license. So let's turn to the other side of the coin, foreign military sales. So when a country submits what's called a letter of request to the US government, and that starts the FMS process, that letter of request goes to another office within OSD policy. It's called the Defense Security Cooperation Agency, or DSCA. And DSCA is like a sister agency to DITSA. So DSCA works with the military services on establishing that FMS case, reviewing from a national security perspective, and then staffs it up the State Department from a foreign policy perspective. And that's where the Office of Regional Security and Arms Transfers provides that foreign policy review of that FMS case to make sure it's in alignment with U.S. foreign policy and national security objectives, and as well as coordinating with the rest of State Department to make sure, from a foreign policy perspective, the U.S. government thinks this FMS case is a good idea. In addition, the military services within Department of Defense are working with the company to establish a contract, right? Because remember, the U.S. defense industry is the one that's going to be supplying those goods and services. And really what ends up happening is, from looking at how the contract gets established, to looking at the national security review, to looking at the foreign policy review, all of those things come together in terms of providing a foreign military sales case to the foreign government that requesting it. And depending on dollar value, and this is true for both FMS and DCS, there'll be a requirement for congressional notification to notify Congress of a proposed sale, whether it's FMS or DCS coming in. And so if you look at both, the same with some slight differences, a majority of the offices that are involved in one are actually involved in the other too. So you really have the same Arms Export Control Act apparatus from a national security and foreign policy review perspective happening on DCS via the export licensing process, and also happening with FMS when the FMS case is getting established.
That's interesting. I didn't know that, actually. But in what situations might one process be preferable to the other, given the similarities and the differences?
That's a great question. And so if you're looking at foreign military sales, we'll start there first. Foreign military sales would be preferable for we'll take the perspective of a U.S. company. A foreign military sales case would be preferable for a U.S. company if this is a first-time acquisition with the foreign customer. So if it's the first time the foreign customer is going to be purchasing a capability like this, FMS will be preferred because you have really additional requirements that the U.S. government is putting on the process to make sure that the U.S. government is buying a configuration and putting requirements on the acquisition like the U.S. government was buying it for themselves. So really, it elevates the level of maturity a little bit to make sure that the capability is really a full spectrum capability that's being provided to the foreign customer. Second is the U.S. government pays its bills. So if you're a U.S. aerospace or defense company and you're working with a foreign government and you're concerned about their ability to pay, or you're concerned about corruption or anything like that, a direct contract with the U.S. government really limits that risk. Third would be if the capability and the technology is very sensitive from a U.S. government export policy perspective. When you're going FMS, there are certain assurances that end up being baked into the foreign military sales case from an end-use monitoring perspective and U.S. government oversight perspective that sometimes doesn't occur with DCS. So there could be a higher likelihood of policy approval that happens for a sensitive capability going FMS as opposed to DCS. Now, so those are the top three FMS reasons. And so for direct commercial sales, where that would be preferred is if this U.S. company has worked with and has done business before with the foreign government, and this is repeat business, and the foreign government has a mature acquisition system, this is a capability they know, then it is a lot easier and faster to just go direct to the supplier, go direct to the U.S. aerospace and defense company to provide that capability. Second is for maintenance and support of a previously acquired capability. So if the U.S. aerospace and defense company is going to be providing sustainment, maintenance, support, those types of services, it's generally easier and faster and more agile to have that occur via direct contract as opposed to a FMS case going through the U.S. government. And then third would be what we call non-programs of record. That's generally preferred via direct commercial sale. And what non-programs of record are when the foreign government has very specific requirements for a particular capability that are different than what the U.S. government would buy for itself. When you try to get a capability that is different than what the U.S. government buys for itself through the FMS process, it becomes very, very hard for the U.S. government to contract that with the company because it's something they're not used to doing. Have you ever gone to a grocery store that's different than the grocery store you go to every day and you don't know where anything is? That's kind of what happens here when you're dealing with a non-program of record going through FMS. And so if you're dealing with a non-program of record type of capability, it's better, if possible, to go via direct commercial sales.
All right. And a question that popped up in my head right now while I'm listening to you is, would it be any difference between FMS and DCS of CUI perspective for the US company? For example, if you go with FMS, it would be logical in my head if the US government took responsibility for identifying CUI information in that specific project. But is the responsibility any different if you were going with the DCS route?
Yeah, that's an excellent question. So when talking about CUI or controlled unclassified information and the protection around that, it is easier going via FMS from a compliance perspective because the U.S. government is great at providing markings to information and really letting their contractors know how information is controlled. Sometimes it's a little bit more conservative, but they're very good at providing those markings. So it is easy for the US company to know what to control and what not to control when operating under an FMS case. When it's direct commercial sale, the burden's all on the company to make sure that they're complying with export controlled information, controlled unclassified information, and making sure they're abiding by those distribution statements accordingly. They don't have a US government contract that's giving them the ground rules, and oftentimes they're pulling information from different sources, from disparate US government contracts, and then combining it all together. And maybe things weren't CUI originally, but when you combine it with other information, it becomes CUI. So it becomes a lot more dynamic and a lot more complex in order to comply with that. That said, so you have to deal, when you're dealing with a foreign military sales case, you have to deal with the US government telling you what the markings are. And if you have a very savvy export control and CUI compliance program where you're able to kind of create good bounds in terms of identifying what that information is, sometimes what you get when you're dealing with the US government is a more conservative interpretation than you would otherwise have if you were operating, standalone as a company.
Yeah, but then you would have your back cleared.
Yeah, exactly.
Yeah. So you mentioned licensing and in terms of direct commercial sales before, but could you explain a little bit the mechanics of ITAR licensing as it relates to the DCS process?
The DCS process or the FMS process?
Both, basically.
Okay. So yes. So from a licensing perspective for direct commercial sales, once you get the approval, it generally comes back with a list of different provisos, and the onus is on the company to really comply not just with the rules that are outlined in the ITAR in terms of post-approval compliance requirements, but the onus is on the company to also comply with the list of technical or administrative provisos and restrictions that come back on the export license. And so some of those provisos can be more administrative, as in doing certain types of follow-ups and checks to ensure the commodity is shipped in a certain way or stored in a certain way. Other times it could be a little bit more technical, limiting the capability of a particular commodity to a certain level for that particular end user. But the burden is all on the company to navigate that, and really at the discretion of the company's empowered official to figure out how to balance the compliance with the license and the compliance with the ITAR with the success of the particular DCS effort. Now, you shift to foreign military sales, and with foreign military sales, one of the tools that exporters have in their toolbox are ITAR exemptions. So there is an ITAR exemption in the ITAR specific for foreign military sales, and there is an ITAR exemption in the ITAR specific to security cooperation programs, which foreign military sales is a security cooperation program. Now, both of those exemptions have a significant burden of proof in order to be claimed. Sometimes it requires written validation from the US government saying, yes, you can claim this exemption in support of this contract. Other times it requires certain language to be baked into your contract as an empowered official in order to claim the exemption. So it's not something that a company can just go and say, I have an FMS contract, so I obviously qualify for the FMS exemption. There's a certain significant amount of due diligence that has to happen in order for that to take place. But once you're able to claim it, your company is getting direction from the US government on how to perform under that FMS case, right? And remember what we talked about in terms of the parties, whether it's FMS or DCS, they are the same for DCS licenses as they are for FMS cases. So when you're getting direction via a contract, it has gone through the National Security and Foreign Policy Review when the FMS case was established. So you actually have less risk operating under the FMS contract because the government has already figured out the bounds of what's within scope and allowed from a national security and foreign policy perspective under that FMS case. And so it's an easier job for the empowered official. It's an easier job internally from a risk management perspective because the rules are being set for you as opposed to you having to interpret what the rules are via DCS.
Sounds very convenient if you ask me. And of course, when you are selling those items or services, they are subject to the ITAR, and exporting those need some sort of licensing. What type of licenses are available and what's the process for obtaining them?
Great question. So when you're looking at the different licenses under the ITAR, the first one that is the most common is what is called a temporary, or no, what is called a permanent export license, or DSP5. So permanent export license, or DSP5, is for the permanent export of either hardware, services, or data. Why services and data have to be permanent? Because once you tell somebody something or provide a service to somebody, you can't get it back. So DSP5s are for the permanent export of hardware, services, or data. And they can be used for the final sale of a commodity. They can be used to support marketing purposes, where you're going to be providing technical information to support your marketing activity. All of that can fall under a DSP5. And when we look at a DSP5, it's valid for usually 4 years. And the US government processing time around that is anywhere between 60 to 90 days. The next license you have is a temporary export license, DSP73. And so a DSP73 is hardware only, because like we just mentioned, once you share information to somebody, it's in their brain, you can't get it back, right? So it's hardware only. And DSP73s are perfect for overseas demonstrations, where you need to take hardware and send it overseas temporarily for a demonstration. They're good for a loan or lease, where you're temporarily lending equipment to a foreign party. They're also good for when you are supporting, you as an aerospace and defense company are supporting the US government overseas. So you're going to support them, and eventually the equipment or the weapon systems coming back to the United States, you're temporarily exporting the commodity out, and then you're bringing it back after some duration. So a DSP73 is good for 4 years as well, usually. And the processing time around that is really similar kind of time frame, 60 to 90 days. Now, the last main kind of export authorization category, it's not really a license, it's a grouping called agreements. And so you have 3 different kinds of agreements under the ITAR. And your agreements are really for more comprehensive direct sales programs. Usually when you engage in a direct commercial sales activity, it's more than just sending the hardware. There's usually an exchange of information, there's usually an exchange of services, and all of that activity gets parked under these export agreements. The agreements overall are valid for 10 years, unless otherwise limited, and are significantly more comprehensive, complicated, and go under more review than the licenses, but you can do a lot more. And so there's really 3 flavors to these agreements. The first is a technical assistance agreement. And so what that is it allows for the exchange of hardware, data, and services. And it's really the most common agreement. And it's what allows for the comprehensive collaboration between the US company and the foreign government to support not just the sale of hardware, but also the services and information exchange around that hardware to make sure it is being used effectively, the foreign parties trained up on how to work with it, that type of thing. The next level up is a manufacturing license agreement, which is all of the approvals and authorization and kind of scope of a technical assistance agreement, but you're exchanging manufacturing know-how. So you're not just working and collaborating with a foreign party, you're now teaching them how to build, manufacture, and develop a particular capability and produce a capability on their own. So it's going to go through significantly more scrutiny with the US government when you're dealing with that type of agreement.
It's like a technical assistance agreement on steroids.
Exactly. Yeah. It's a great way to put it. And then the third is, and this is a very unique agreement. In my experience, they're generally rare, but they do occur. It's called a warehousing and distribution agreement. And it's really like a manufacturing license agreement without the exchange of manufacturing know-how, but still distributing the goods and services to multiple end users and multiple parties. So what a warehousing distribution agreement is it allows for really the export and storage of particular goods and goods in a foreign government or foreign country for them to go resell and distribute to a certain network of countries to the next level of retransfer. So it's like a technical assistance agreement on steroids if the steroids were only in the retransfer clauses and re-export clauses.
Yeah, that's great.
Yep. And so those are the different authorizations, and there are some that are additional ones that are for more of amendments and that type of thing, but those are the core ones. And then on FMS, it's really, you're trying to park as much under those exemptions as possible, but sometimes you do have to branch out and use the ITAR export licenses to support the FMS case too.
Yeah, of course. And what's the common pitfalls exporters should be aware of when navigating the ITAR licensing process?
So first would be prior planning and making sure you're building in the ITAR license processing times, as well as data gathering to develop these authorizations into your sales process, and backward plan when you need to start licensing if you're going to make a delivery date by a particular time. Oftentimes we see our customers not really factoring that in, and because it hasn't been factored in, the date that they promised a particular country delivery of a capability is actually 2 to 3 months later than when they actually promised that foreign customer the delivery. So that's first. Second is a lack of US government pre-coordination. So particularly when you're dealing with sensitive technologies or new and emerging technologies, pre-coordinating with the US government is essential to make sure you get the export authorization approval that you want. So the folks in the US government that review these applications, they're people just like you and me. And the only information they have on a particular capability is what you submit with the application. So sometimes things get lost in kind of that review that are essential to making the approval, be as positive as you want. So we always recommend to our customers going and pre-coordinating with both the foreign policy reviewers and the national security reviewers to make sure they all understand the bounds of what it is that you want to do, but even more importantly, what you don't want to do and what you're not going to do in your application. And then third, post-approval compliance. So we see with our customers sometimes that they feel once they get the export license, the export approval, it's like, oh, we're done with the ITAR process. We don't have to really worry about anything else here on out. And that couldn't be farther from the truth. So most violations that I have seen of the ITAR occur post-license approval. And it's when a company ignores the provisos that come back on the license, they ignore the post-approval compliance requirements of the ITAR, and they think that, once they got the approval, they're done with needing to worry about the ITAR. And so understanding that your ITAR export licenses are things that need to be actively managed from a post-approval perspective, just like your contracts do, is something that a lot of companies miss, and it causes a significant number of violations.
You cannot stress that enough, because if you get an ITAR license for a specific component, it's not over even if the ITAR license has gone out of time. It's basically a lifelong commitment and the lifespan of the product.
Yep, exactly.
So the product and the compliance requirement can survive us all, basically.
Correct. Yeah, it's especially with, I mentioned, technical assistance agreement being valid for 10 years. 10 years. So, and you can get it amended for an additional 10 years after that if the US government approves it. How many people, are working at a company on the same product or program for 20 years? Very rare.
Yeah, very rare, I believe. So you have already entered that area of post-approval. And the next topic is requirements exporters must abide upon approval of an export license. So what are the typical end user and end use verification procedures implemented after receiving an export license?
Yeah, that's a good question. And so there's a category in the ITAR called significant military equipment. And what that is are specific sections of the U.S. munitions list that have been identified as particularly sensitive. And so commodities that are either classified or are identified as significant military equipment actually require a end use and retransfer certification from the end user and foreign consignee to be included with the license application, or sometimes uploaded after the license application. And what that is really the foreign end user or foreign government signing that they're not going to retransfer or re-export the particular commodity outside of the scope of what is included in the authorization. So that's one of those things where we'll start with extraterritoriality of the ITAR. That's one of those where, you not just the exporter has to worry about it, but even the end user has to worry about it.
Yeah, yeah, of course. And I believe it's DSP 83 you're referring to.
Correct.
Yeah.
Correct. Yeah. DSP 83. And it, that also includes who the foreign government is using in country to maintain the particular defense article, right? So just because they've allowed, or the U.S. government has approved the country to receive the defense article, doesn't mean that they approve the use of private contractors or foreign defense companies to go and support the defense article. And so keeping track of the bounds of the authorization is a foreign end user's responsibility just as much as it is a U.S. defense company responsibility. So shifting to the U.S. defense company in terms of post-approval requirements, a big one is the record keeping requirement. So all records need to be maintained for 5 years from the date of export. And your export records include the usual who, what, when, where, why, how information, and have that information included in really the file that you have and are maintaining your export authorizations in, ideally in a centralized record keeping methodology. That ends up being an industry best practice. So that's one. Second is reporting. So all of the authorizations that I mentioned have some kind of reporting requirement in order to export or throughout the life cycle of the authorization. So not only do you have to maintain records, but in certain instances, you have to report back to State Department how you're using the authorization. Some of those reporting requirements include initial export notifications to State Department, making sure you're filing your customs paperwork appropriately, notifying State Department when your agreements have been signed and executed by all parties, notifying State Department when you haven't executed your agreements with all parties and you still want to use the agreement in the future. So there are a lot of those. Sales reports for manufacturing license agreements of once something's manufactured, which countries it's going to. So it really is a situation where these export authorizations have to be actively managed to keep up with all of those requirements.
Yeah. And now to the scariest question. What's the consequences of non-compliance and how can it be mitigated?
Excellent question. And so I believe it's been maybe a month ago, the civil fines and penalties were just increased by State Department by a little bit. And so right now, per individual violation, there's a civil penalty of up to 1.2 million and change dollars per civil penalty per individual violation of the ITAR. And when we tell our customers, it's actually really hard to violate the ITAR only one time. So the way it's structured is if you do a shipment wrong or an export wrong, or you're engaging in activity under this export authorization and you do it incorrectly, usually you violate the ITAR no less than 5 times. And so because of that, if you screw up the violations stack very, very quickly against you. So you hear 1.2 million, it's really exponentially larger than that when you have a violation of the ITAR, when you factor in all of the different subparagraphs that you violate when you mess up. And that's just the civil penalty. On the criminal penalty, and this was for willful acts of violating the ITAR, you're looking at not just fines, but also imprisonment and debarment, and of both the export variety as well as the contractual variety too. So if you're an aerospace and defense company, you live off of your contracts with the US government. And so let's say State Department, because you violated the ITAR in a really egregious way, doesn't even want to fine you. All they have to do is say your government contract privileges are now debarred and withheld for a period of 5 years. Imagine being a company where your sole source of income are government contracts, and you're told you can't get any for 5 years until you fix your compliance program. Those companies will shut their doors, right? Those will be company killers. So, when it comes to the fines, when it comes to the risk of export contractual debarment, when it comes to the risk of reputation loss, right? Like, when you're under consent agreement and you violate the ITAR, there's a big publication coming out of State Department about it that includes all the different areas you did violate the ITAR, what your mitigating factors are, and it's all out there for the world to see. So, even if the fines don't scare you, or even if the government contract debarment or export debarment doesn't scare you, going and facing new customers with kind of the scarlet letter, on your shirt, that generally makes it a lot harder to get business to.
It's not a very good selling pitch.
No, and actually, even informally, so we heard of a company where they were under consent agreement and they were doing all the right things. So they were under a consent agreement with the State Department and they were doing all the right things. They were investing in their ITAR compliance program. They knew they screwed up. The fine wasn't that big, but they were informally labeled as persona non grata within the special operations community in the United States. So decided that, hey, this company is too much of a risk. We're just not going to give them contracts anymore, even if we know that they're trying to fix their stuff. It's just something that we'll go buy from somebody else, right? That's just informal like that, and that can really, really hurt a business.
Yeah, it really can. Looking at my sheet note here, I'm all out of questions except for one. If you haven't anything to add to the mix.
Yeah, so I would just say that for companies that are looking to engage in international and are serious about engaging international, it is better to invest upfront in either hiring the right expertise in-house or asking for professional help externally to get things started on the right foot before you get too far down the road and then decide you have to go and build out an ITAR compliance program or figure out if your products are exportable or work with the US government to make sure you have approval to export your capability. All of that can be done up front, and it ends up being significantly less expensive, significantly less draining on the business, and usually you get a better result if it's all done up. So if you're serious about international, don't cut corners with respect to global trade compliance. Invest in it up front and then go after and capture the business.
Yeah, it's always less painful to learn the regulations before you need it.
Yep. It reminds me of this cartoon that I saw once, and it is of a general contractor building a house and installing a new window. And the house, you see the foundation completely crumbled. And he's trying to install this window, and he's like holding up, like he has all these different boards holding up the foundation and then the drywall to just install this window. And you see the GC there sitting talking to the owner of the house, and the owner of the house is asking the GC, why is it so expensive to install just a window? The GC is sitting there just like, oh, brother. So having that strong foundation really makes things a lot smoother when you're trying to do other things.
Yeah, that's a great analogy. So my last question is, if people want to get in touch with you, how do they do?
Yeah, so thank you. Thank you. And the best way to get in touch with us is really twofold. One is to go to our website at defense-trade.com. And on our contact us page, you can shoot us a note and we'll get back to you usually within 48 hours. A second way is follow us on LinkedIn. So if you search for Defense Trade Solutions on LinkedIn, you'll be able to go to our page. And on that page, you can either direct message us if you want to get in touch or tag us in a post. And we'll definitely be responding to you and see how we can help.
That sounds awesome. And I'll be sure to put some links in the show notes as well.
Thank you. I really appreciate that.
And I really appreciate you taking the time talking these awesome ITAR US trade compliance related topics with me. It's been a ton of fun, and hopefully it will be valuable for everyone that listens to it. So a big thanks to you for taking the time.
Anders, thank you for reaching out, and it's really humbling and an honor to have been on your podcast. And if you're interested in talking about these types of issues more, happy to do it again. So, thank you, and really appreciate you looking to me to be a guest.
That's awesome. I'll be sure to